Thank you very much for your attendance here today. You can see by the number of people in the room just the interest that this topic has generated. For those of you who haven't met me, my name is Tim McKibben and I have the pleasure of being the CEO of the Real Estate Institute of New South Wales. The legislation, it's still, the ink's still wet on the pages, to be frank with you. We're still trying to get our head around what it looks like, what it actually means. A comment was made to me the other day about there's 85, I think there is 85 tribunal members, so we're anticipating getting around about 86 different opinions about what it's going to look like. So that seems to be the way it works. So we're still trying to get our head around actually what it means. We're also working with the Office of Fair Trading very, very closely. In fact, I was just talking to Tim about a meeting with them we'll be having shortly. So what we hope to do today is to give you an overview about the Act, get it on your radar. It is probably one of the most sweeping changes to this particular piece of legislation since about 1987. Is that right, Tim? Okay.
Certainly.
Tim goes back to about, I think now and again he says to me, oh, I remember this happening in 1963 and 65 and these sorts of things when I was aspiring to play under sevens. But anyway, so Tim's history of all of this is all the way through. I get away with that. But anyway, folks, you've got the Tim and Tim show today. So hopefully you'll find today a little enlightening, and I'm sure it's going to raise some concerns. Thank you for your attendance.
Welcome to the Residential Tenancies Act 2010. It's now a reality. It's gone through Parliament. The final assent was on the 23rd of June. Quite a number of alterations. How many people in the room actually saw the draft bill before it went, the other bill went into Parliament? Many of you obviously didn't read it. There were a lot of issues in that engendered a huge amount of fear with all of us, and that actually started a fairly strong political campaign to have some of these things changed. Basically what we're going to talk about today, as Tim says, we've only got 2 hours, so it's not a lot of time to get into the real meat of what's in this bill. There's a huge amount of change. Some of it only small bits, but you need to pick up on the small bits, otherwise you're going to come apart at CTTT. The progress so far, we had an options paper in 2005. Real Estate Institute was involved in putting in a fairly major submission. Then we had OFT discussion paper in 2007. We actually put in a submission there with 102 items in it, just reacting to what the government was thinking of doing. November this last year, 2009, we saw the first of the release of the draft bill, and that put fear into all of us because frankly there were a whole heap of things in that were just not, would make the whole exercise unworkable. It was interesting to note that talking to quite senior members of the tribunal when this bill was, the draft bill was released, and they just said it won't work, can't work. So the combined efforts of organisations like the Real Estate Institute, the individual members who actually went out there and confronted their own members of Parliament and said, do you realise what you're doing to residential investment in New South Wales? If it had gone through unchanged, a very large proportion of your private investors would have left the state. There's no question about that. So the good news is that as a result of pressure that has been brought to bear, the government has listened to the marketplace, and quite a lot of the stuff that we really feared has been left out altogether. A lot of what we're doing is making our own interpretation of the new law. As Tim said, there is no regulation yet. A lot of the interpretation of the law as it stands will come from decisions of the CTTT and eventually from the District Court, which is now the appeal mechanism rather than the Supreme Court. So it's all new stuff. We've spent a lot of time going over it, trying to pick out the areas that would cause most concern or the things that you'll need to know about to get going with it. The time frame is interesting because obviously with a change like this, and it's a major change, it's the similar sort of impact that we got in 1987. And there's a lot of things that need to be done before it can become operative. Government's pushing really hard. Obviously, they're looking at election very early next year. And we've got a situation where this bill well could be in force in September this year, September. Now, that doesn't give us an awful lot of time to get on top of it. It doesn't give us an awful lot of time to produce documents that need to be changed to comply with the new bill. So let's just move on a little bit. What I won't be talking about today is social housing. Some of us, a lot of us that in business do business with social housing by having the department as head tenant with the idea of subleasing. Those arrangements between yourself and the social housing will be as this particular bill will dictate, as a landlord-tenant relationship. The social housing side of it is from the head tenant to their tenants, the social housing tenants, and that's different. There's a whole section in the Act that deals with that, but it's not really relevant from a practising real estate point of view, so I'm going to bypass that. The other one is that I'm not going to talk about very much, if at all, is the tenancy databases. The restrictions that were brought on tenancy databases through Property Stock and Business Agents Act are virtually the same and translated over into this piece of legislation. So there's been very, very little alteration with that. The other key change is that the Rental Bond Act has been repealed and the provisions of the Rental Bond Act are now part of the tenancy law. So there's a whole section of the Act which comes to some 135 pages, I think, of this new bill, but part of that will be exclusively the provisions of rental bond. Now, what didn't get in? The one that caused the most alarm to us was this right to break a fixed tenancy. Those who heard me speak prior to, it was a major concern from my point of view that you could have a fixed term tenant where the landlord was bound for whatever the fixed period was, but the tenant could get up and walk by giving 2 weeks notice and paying what they called a break fee. Now, that has been completely eliminated from the bill. It's not there. The only place where it is, it's now in a situation where it's optional. It will be in some form in the new tenancy agreement, but it'll be an opt-in or opt-out basis. I can't imagine any real estate agent, unless they're needing brain surgery, would allow that clause not to be struck out. Now, the first draft which we've seen does indicate that the clause will be there about break fees, but it won't be, it'll have to be crossed out. That was the first draft. We're still not happy about that because the way it went through Parliament was quite clear that it shouldn't be in there in the first place. And it's provision there to do with abandonment of property, which we'll talk about a little bit later on, that the break fee can actually be levied if it is part of the agreement. Okay? So our duty as an agent will say, okay, owner wants break fee or not break fee, you're going to have to get it out of the agreement somehow, either we're crossing out an initialing or whatever. But we haven't seen the actual draft yet. We're hoping to see that this week, right? Yeah.
We're
today.
Hoping, we're hoping to see
the first draft anyway.
Yeah.
But there's a lot to be changed there. But the good news is that it's not the horror we thought it was going to be. So we're pleased to waive that one.